Good morning, and good afternoon, and good evening, depending on where you're tuning in from. Thank you for joining us for our second Women in Nuclear Law Initiative webinar on nuclear law considerations for advanced reactors. We have over 80 people from around the world who have registered to participate in this event. To ensure a stable connection and considering the number of attendees, your video and audio functions have been disabled. You can still actively participate in the discussion by expressing your views, sending us your comments, and asking questions via the Q&A feature. Please note, we may not have enough time to take all of the questions online, but we will do our best to treat them after the event. Today's discussion is being recorded, and the recording will be made available online in the near future. With us today, we are grateful to have 6 experts from around the world who will each be speaking on different aspects of the topic for today's webinar. First, I'll briefly introduce each of them before we start. We have with us Mary Spencer, Deputy General Counsel for Licensing, Hearings, and Enforcement from the United States Nuclear Regulatory Commission. Zoriana Vovchok, the Director of the Legal Affairs Department at the Federal Authority for Nuclear Regulation of the United Arab Emirates. We have Olipa Jere, Deputy Chief Parliamentary Counsel, Ministry of Justice from Zambia. We have Beata Sparazinka, Counselor, Nuclear Energy Department, the Ministry of Industry of Poland. We have Else Reiners Keeney, a partner from MV Keeney and Company, India. And we have Kristen Weiss, an associate from Assmann Pfeiffer Rechtsanwälte Partnerschaft, Germany. Thank you all so much for taking the time to be with us here today. And without further ado, I will turn the floor to our first speaker, Ms. Mary Spencer. Mary, the floor is yours.
All right. Well, I'll say good morning since I'm in the United States and it's 7 o'clock in the morning. And I would say that I might be a better presenter if it was at 1 o'clock in the afternoon, but I will do my best this morning. So my presentation was asked to speak about adapting a prescriptive regulatory framework for new technologies. So next slide, please. So the existing regulatory framework for nuclear power reactors in the United States is premised on large light water reactors and the risks that are attendant with such large light water reactors. These requirements are not necessarily necessary or appropriate for smaller reactors or non-light water reactors, as they tend to take a one-size-fits-all approach. Next slide, please. So, driven by the need for clean energy data centers, interest is now in small modular reactors and microreactors. These are reactors constructed in factories, not on sites, reactors fueled or maybe even tested at the factory, reactors that are transported potentially back to the factories for refueling and refurbishment, reactors that don't have licensed operators or they're operated remotely, reactors that are closer to population centers, including reactors that may be placed at former coal or gas generation sites. And of course, reactors that are not light water cooled. So in short, all of our assumptions in our existing regulatory framework have been challenged. The US Congress has also responded to this demand by enacting legislation directed at the NRC and its regulatory regime. So first we had NEMA, the whole name is on the slide, in 2019. And then last summer we had the ADVANCE Act. The new administration has also responded to this demand and interest in nuclear power via executive actions, most particularly Executive Order 14300, ordering reform of the Nuclear Regulatory Commission. Next slide, please. The table on this slide shows advanced reactor interest at the NRC for both non-light water and light water, and for commercial and research test users. All these applicants have notified the NRC or are engaging with the NRC right now in the licensing process. I would note that we have already issued construction permits to Kairos, Hermes for 2 test reactors, and to Abilene Christian University for a research reactor. TerraPower, it's on this slide, has a construction permit application pending, as does X Energy or Project Longmont. We've also issued early site permits to the Tennessee Valley Authority for the Clinch River site, and we expect a construction permit from Kairos shortly. So these actions show that our existing regulatory regime can be adapted to accommodate new technology. Next slide, please. So Section 208 of the ADVANCE Act neatly lays out the issues that need to be scaled to address small and micro reactors. We have and are addressing these issues through a variety of initiatives at the NRC. In addition to scaling, there is a desire to create more risk-informed, performance-based regulations. We've long been moving in this direction, but we are being directed to move further in that direction. Moving to a risk-informed, performance-based regulations is intended to provide more flexibility and scalability for different technologies and different sizes of reactors. Next slide, please. So here are some actions aimed at addressing new technologies and making our requirements adaptable to the risk profiles of advanced technologies. Part 53 is our headline effort to create a risk-informed, technology-neutral framework. This effort started following the passage of NEMA in 2019. A key challenge of this effort is trying to make it adaptable to all sizes of reactors. Next bullet is something that we've actually done, is a final rule on emergency preparedness for SMRs and other new technologies. This rule revised EP emergency planning requirements that were premised on large water reactors to create an alternative emergency preparedness framework that is performance-based, technology-inclusive, risk-informed, and consequence-oriented. In other words, it provides an alternative to the existing one-size-fits-all approach. Another action is a rulemaking on alternative physical security requirements for advanced reactors that would adapt our one-size-fits-all physical security requirements for small modular reactors. It would establish a voluntary alternative to our existing requirements, commensurate with the potential consequences to public health and safety and the common defense and security. So we think this rulemaking would provide clarity and consistency for and minimize or eliminate uncertainty for advanced reactors applying. Then we recently launched, in response to the Executive Order 14300, a microreactor rulemaking. This rulemaking is intended to answer the directive in the executive order, requiring us to establish a process for high volume licensing of microreactors and modular reactors, including by allowing standardized applications and approvals, and by considering to what extent such reactors or components thereof should be regulated through a general license. So this is expected to be a very fast-paced rulemaking. I will note it's a little bit of a divergence, but we are also working on a rulemaking for fusion machines. Fusion machines is the term that's used in our legislation. And this would apply a materials licensing approach, not a utilization or production facility approach, to licensing the radioactive materials used or created by a fusion machine. So we wouldn't be regulating the device, we would be regulating the radioactive material used in it or produced by it. Next slide, please. With respect to the first item on this slide, the NRC staff has already issued a significant volume of guidance on technology-inclusive, risk-informed, performance-based applications. This guidance supports near-term advanced reactor applications under our existing regulatory framework, and also supports licensing under our new framework that we're developing under 10 CFR Part 53. The second item reflects ongoing work on the environmental review aspects of reactor licensing that's required under our National Environmental Policy Act. Part of this effort has been the development of a generic environmental impact statement for new reactors. The goal of this project is to codify via rulemaking the environmental impacts of advanced reactors to streamline the environmental review process. The NRC staff is currently working on the final version of this rulemaking. And next we have on the nth of a kind paper, which the NRC staff is seeking commission approval to afford finality to standard operational programs or requirements submitted by applicants and reviewed and approved by the NRC staff in connection with design certification or manufacturing license. Currently, the NRC does not afford finality to these operating programs in design certifications or manufacturing licenses. So changing this is expected to expanding what can be approved as part of a standard design or a manufacturing license is expected to facilitate the licensing of multiple reactors of the same design. The paper also discusses steps the NRC staff is taking to streamline the environmental review process. And then the last item noted on here is the microreactor SECI paper, 2024 paper, and which the staff sought commission direction on approaches to authorizing fuel loading and operational testing at a factory. So in June, the commission issued its direction, responded to the staff's paper of this year, June of this year, and gave this staff direction that will allow the staff to proceed with developing a rulemaking on factory fuel loading and testing. That will be separate from our Part 53 rulemaking effort because it's not addressed in Part 53. Next slide, please. So while we have many initiatives underway to update our guidance and regulations, the NRC can license new technologies now. We can do two things at once. As noted earlier, we have granted early site permits and we're actively working on construction permits for small non-white water reactors. We've also certified two SMR designs. We did one design certification, one standard approval for new scale designs. So those are ready for market. Before I conclude, I wanted to note that the NRC does have additional tools in our toolbox to address novel situations, and one of those is exemptions. And we can grant exemptions when it's authorized by law, which means not contrary to express legal requirements, and will not present an undue risk to public health and safety, and is consistent with the common defense and security when special circumstances are present. So this provides flexibility, but not any reduction in not less safety. So while we have a prescriptive regime, we are moving towards a more performance-based, technology-neutral, and scalable approach. There is a push and a pull between being prescriptive and being performance-based. When you're prescriptive, everyone knows what's expected. When it's performance-based, the requirements may be less clear. So balance is needed between prescriptive norms that can be relied upon and providing flexibility for innovation and advancement. So we're working to adapt our regulatory requirement, and we're well on our way. Thank you.
Thank you very much, Mary. Sounds like lots going on.
Yes, a lot's going on.
Yes. And now I will give the floor to Dr. Zoriana Vovchok. Zoriana, over to you.
Thank you, Lisa. Thank you for this introduction. And it's my pleasure to speak about the UAE's legal and regulatory framework and how it is evolving to support a future with the SMRs and advanced nuclear technologies. So the legislation that we have in place that was issued in 2009, we can consider as being forward-looking legislation. This is in the consideration of the definition of the nuclear reactor that we have in the law, which is rather broad, and it defines it as the device with a nuclear fuel, which is used to control nuclear fission reactions. And the definition includes research reactors and power reactors, and is sufficiently broad to include SMRs or advanced nuclear reactor designs. However, as we can notice, it is limited to nuclear fission reactions. And as concerns advanced reactors, it would cover only those that are fission-based reactors. Inclusion of other types of technologies, such as fusion, of course, will require an amendment of this law. And at the same time, other law that we have, primary legislation, it concerns the civil liability for nuclear damage, is also limited to fission-based nuclear reactors. I'm sorry, I didn't mention these slides to be moved to the next slide. Yeah, thank you. So the same is also in the Vienna Convention civil liability for nuclear damage, to which the UAE is the party, the 1997 version. So in order to accommodate such SMRs, the UE also doesn't need to change the policy for the evaluation and potential development of peaceful nuclear energy, which was issued in 2008. We can consider that policy also as being forward-looking because it mentions the support of the UE government for the development of future technologies and designs. The policy states that the UAE will be favoring proliferation-resistant technologies and designs, and adds that high importance will be placed on innovative reactors and fuel cycle technologies that exhibit enhanced proliferation resistance. And the UAE would proactively support the development of such technologies. As the policy served being the basis for the legal framework for the nuclear sector, the law number 6 of 2009 established the Federal Authority for Nuclear Regulation, the regulator which I represent, and it enabled it to issue licenses to operate nuclear reactors for a period of up to 60 years. So all of the 4 units of the Baraka nuclear power plant are licensed for operation for 60 years here in the UAE. But the same legislation also provides for the authority for funder to issue regulations concerning the duration and general terms of conditions of any license. So possibly when we have to work with the SMRs and other technologies, that would be also looked into, and other timelines for the duration of the license will be considered and studied. Also, the same legislation allows funder to grant exemptions within the limits of international obligations and agreements for facilities and activities that do not represent a substantial threat. The legislation also gives the authority for funder to be exclusively responsible for issuing licenses to practice any of the regulated activities that are covered in the law, and those concern the nuclear facilities, but also the legislation enables the regulator through its regulations to designate other types of regulated activities. So the legislation allows funder to issue numerous regulations, which is one of the prerogatives that allowed this nuclear program and legal and regulatory framework to develop fast. Next slide, please. So to date, funder issued 24 regulations establishing binding requirements for regulated community, and those are mainly performance-based. funder reviews its regulations every 5 years, or as may be necessary. And so far, we haven't done yet full analysis of the readiness of the regulatory framework for the SMRs. Next slide. However, in 2024, last year, through the revision of Regulation 8 on physical protection of nuclear material and nuclear facilities, funder included a definition of advanced nuclear technologies and Article 29 dedicated to the same subject. So in order to come up with the definition, we studied the approach used by other regulators, and those are briefly indicated. The logos of those are on this slide. So as per the regulation, the advanced nuclear technologies include a wide range of innovative nuclear technologies, including SMRs, advanced modular reactors, which may vary depending on their size, scalability, location, modularity, application, fuel types, cooling medium, remote operability, and so on. We haven't defined the SMRs per se, nor the advanced modular reactors, but the effort that was put forward with this revised regulation was to introduce the early engagement of the regulator into the work with those who are planning to deploy the advanced technologies in the UAE. So we want the funder and those who are planning to be involved together in the stage of development of requirements for the procurement of those technologies, and to ensure, at least in the context of this regulation, that the physical protection and cybersecurity measures are considered. And with information exchanged, they would also seek additional guidance from the regulator. On the basis of this engagement, the regulator will determine whether the license is required and will enhance its regulatory licensing requirements. On the other side, even if a regulatory framework is not there yet, the specific requirements can be put forward in the form of license conditions in the license itself. And this has been the approach already put in place by the UAE for the licensing of the current nuclear power program. So further, in case the license is required, the requirements of this current regulation 8 will be applied in a graded manner that will be determined by the authority on the case-by-case basis. So that would be the approach that is used in the physical protection area. And as the regulation entered into force end of January this year, this regulation marks the first formal step of FUNER in addressing SMR-specific requirements, though just at the early stage of that. Next slide. Next slide, please. Yeah. Upcoming regulatory milestones include plans for new regulations. So we do have regulations master plan that covers the period from 2025 through 2029, which is approved by our Board of Management. And we do put into considerations plans for regulation on advanced nuclear technologies, which we plan to have finalized and issued in 2028. Also, we work on the regulation civil liability for nuclear damage because we need to study whether there is a possibility to have lower liability limits for other types of reactors such as SMRs, and this would be in line with our liability law, according to which the regulator may establish lower limits in relation to nuclear installations consisting of research reactors, low power reactors, but those limits should be not lower than 5 million special drawing rights. Next slide. Besides the aforementioned legislation providing for specific mandate for FUNER, the nuclear regulator, there is another piece of primary legislation in the UAE. It's the Federal Law by Decree number 25 of 2018 on the projects of future nature. And according to this law, the UAE cabinet can issue minimum viable license for implementation of any innovative project based on modern technologies of a future character or using artificial intelligence if there is no legislation in the state to regulate those technologies. And the purpose of this approach is to prepare legislation to regulate activity of the project in the state for testing periods at least. The issuance of such minimum viable licenses will require involvement of competent government authorities. So in case if there is any technology that is to concern the regulated activities, the nuclear sector, radiation sector, which is under the jurisdiction of the nuclear regulatory body, of course, there will be engagement with FUNER. And we are already in contact with the cabinet in this regard, but so far there are no activities necessitating our involvement. Just to give an example as to the types of licenses that were issued by the cabinet under this legislation, those included some unmanned vehicles and cargo planes and so on. Next slide, please. So is there any plan, or are there any plans in the UAE for the development of the SMRs? And the short answer is yes. So there is the nuclear industry developments which are led by the Emirates Nuclear Energy Company that has been since the beginnings in the establishment of the nuclear power program, primarily was known as the Emirates Nuclear Energy Corporation. And it embarked on the advance program in November 2023 to evaluate next generation nuclear options, including SMRs and microreactors and advanced reactors. And to this effect, ANEC concluded numerous MOUs, and information about those is available on the website of ANEC and in other open sources. So here are just a few examples. So far, there are no engagement as concerns those activities. The ANEC is aware of new requirements that are put forward by FUNER in the revised regulation, requirements for advanced nuclear technology. And in case there is any development, of course, in order to ensure compliance with the regulatory requirements, they will be in touch with FUNER. So to sum up, the UAE legislative and regulatory framework is primed to support SMRs and advanced nuclear reactors, which are based on the nuclear fission. If there are any other new technologies to look into, there are other innovation pathways that I mentioned, and those can be looked into jointly, FUNER and the cabinet and other entities. So there are mechanisms to enable preparation of legislation and to stimulate that innovation pathways should there be a determination that to proceed with such new technologies. Thank you. This concludes my presentation.
Thank you so much, Zoriana. Also, like in the US, lots of stuff going on. I'm fascinated by the minimum viable license idea. Very fun. So thank you. And now, without further ado, I will turn the floor to Ms. Alipa Jerry. Alipa, the floor is yours. Alipa?
Yes, thank you so much. Thank you. So I'll give a brief, just a brief presentation on key considerations for an embarking country, which is still in its early stages, giving an example on the Zambian scenario. Next stage, please. Next slide. Thank you. So what is an embarking country? So basically an embarking country is one that has expressed its intention or desire to go nuclear, or rather a country that has decided to include nuclear in its energy mix. So this is a country which maybe perhaps uses its electricity energy, maybe from solar or hydro, and now they are considering on including nuclear energy. So this is considered as an embarking country, which is considering to include nuclear energy as part of its energy mix. Next slide. So one of the key considerations that an embarking country must consider is its legal framework. So basically, a country will have to understand the legal framework from the international level, that is to say the international instruments that regulate the use of nuclear energy. So it needs to understand and also ensure, or rather make an effort to join these relevant national instruments. Then secondly, it also has to enact a comprehensive nuclear law, because obviously without nuclear law, a law is used as a vehicle for change. So if you want to embark on nuclear energy, there's serious need that a country must consider revising its laws, or rather enacting a new law that will regulate the nuclear energy, and also revise already existing laws. So you might find, for example, laws such as the ones that regulate that safeguards the energy of that particular country, or that regulates the already existing energy sources. So they might need to be revised or rather amended so that they are in harmony with the new nuclear law that will be introduced. And the fact that nuclear law is highly technical, there will be need, of course, to also consider capacity building for the lawyers that will be involved in drafting and also interpreting these nuclear laws, and to ensure that once the new nuclear law is enacted, it is consolidated. It consolidates all those international obligations to which a particular embarking country will domesticate at international level. Next slide, please. So then the other aspect that an embarking country will have to consider is capacity building. Obviously, you agree with me that before a country goes nuclear, it does not have people that have got technical expertise to not only operate, but also to manage a nuclear power plant. So it needs to consider capacity building, develop knowledge and expertise in the nuclear field itself, and also establish effective knowledge management systems. Here, also what a country needs to consider is that there will be people that will be, they could be retiring or changing from one industry to another. So a country will have to ensure that the knowledge that it will build, the expertise it will build, it is well managed. So it needs to develop a comprehensive knowledge management system to help retain the knowledge next generation. So in ensure that this is achieved, there is need to develop to promote rather a mentoring culture in the nuclear field. So this would not just mentoring in the technical aspect, but also in the governance structure. An embarking country will also have to invest heavily in advanced research and development to meet the new evolving challenges that comes with the nuclear energy sector. Thank you. Next slide, please. Funding considerations. So most of us are aware that to operate, or rather to embark journey, a country will really have to invest heavily in this sector. So first of all, apart from just investing in its human resource, it also has to invest in critical infrastructure development and develop a robust legal framework. So this will also include securing funds for HRR development, pre-feasibility studies, and a regulatory setup. So regulatory setup may include, if there is no existing regulatory body that regulates radiation or nuclear facilities at a small level, then there'll be need to set up an independent regulatory body, which will need heavy funding and also ensure that it is well capacitated in terms of human resource. It is important that an embarking country sets aside these funds, because when it shows that a government is committed, it also helps to build investor confidence. And in that way, you are inviting investors to come and also help in the financing of the whole project. And we are aware that most developing countries, by the way, also lack critical infrastructure for nuclear deployment. So this is key. Before an embarking country actually makes the decision to go nuclear, they must consider, or rather set aside, heavy funding for for the development of its infrastructure. Next slide, please. Thank you. Yeah, this stakeholder engagement. This is a very key consideration, in that it will determine to a larger degree the success of a nuclear project. Early engagement is crucial before a decision is made. So it's not just engagement. You need to involve the stakeholders, must be involved in the effective engagement. It's not a one-way flow of information. You need to engage them and ensure that they are involved in the whole process from the word go. So this is where I think I'll give an example where you will need to engage even journalists. Journalists could be engaged, to help spread the information, and perhaps even develop a very robust strategy on stakeholder engagement, because they do have to some end, they do determine the success of a project. So you need to engage the stakeholders, because we understand that the public perception also is likely to hinder a country's progress in the development of a nuclear energy project. So it's important that all the myths are dispelled through this stakeholder engagement, and develop an open dialogue between all actors. It will help to strengthen the success of the project. Next slide, please. So for most developing nations, for example, even Zambia itself, there are a lot of competing other competing national needs like education, health, and many other sectors, of course. So you find that there's need to understand a country's what is a country's most priority needs at that particular moment, because embarking on a nuclear energy is quite costly, manageable, but it needs a country's commitment. So they need to, before a decision is made, they need to weigh the options, should we concentrate on energy or healthcare, and other priorities that may affect national positioning. So these need to be considered critically before a national decision is made for an embarking country. And the decision to go nuclear must be strategic and not political, in that there's some countries where political parties will hold power for 5 years. So when a political decision is made, when a decision to go nuclear is made, it must not be a political decision, because 5 years down the line, when the next political party takes over, it's likely that it's 50-50. It might be adopted, it might not be adopted, in as much as it shouldn't be the case. But in some instances, some countries will find themselves in such a situation. So it must be a decision that is strategic, in that you are basing your decision based on the needs, for example, to secure, energy security for the nation. So it must be a strategic decision. Next slide, please. Yeah, so in summary, I think I would say the IAEA milestones approach publications, I think, do offer a very comprehensive guidelines for those countries that wish to embark on nuclear energy. And the fact that it recognizes the legal framework as a key element in nuclear infrastructure. Therefore, countries must address legal and institutional frameworks early in the planning process. Thank you.
Thank you so
much for your attention.
That was great. Thank you so much. I will now give the floor to Ms. Beata Sparatzinka. Beata, over to you. Beata?
Yes, thank you very much, Lisa. Sorry, I'm on the online version and it just works much slower than the installed one. I'll just share my slides now.
We can see them. Looks good.
Oh, you can see them already?
I did. Now I don't.
Okay. Okay, because it's strange. Can you see them now, right now?
No.
Okay, so I'll go back to, just apologies about that. How about now?
Yes, they're there. Perfect.
Okay, fantastic. And they're moving, yes? Okay. So once again, thank you very much. Good morning and good afternoon to all the attendees. I'll just start by saying that, as in the Zambian case, Poland is considered an embarking country.
I think we've lost the sound. Did we lose Beata? Beata? Okay, so if we've temporarily lost Beata, perhaps we should move on to Else, should we? And we'll hopefully come back to Beata. So I will move on to Ms. Else Reiners-Keeney. Else, if you're ready, please go ahead.
Yes. Happy to jump in. Yes. And yeah, I'll also wait for the next slide. And I just start by a little, you can go to the next slide. Yeah. The chart of India and its 25 nuclear power plants. And I just find it captures a lot. It indicates, so 25 nuclear power plants, yet only 8,780 megawatt as on date. So it immediately tells you, I find it captures very well the history of India, which um, since its independence in 1947 has always had a nuclear program. So it's not a newcomer country in that sense. It may have been a slow moving country. But what it tells you is that the initial designs, they're about 14 of its nuclear power plants out of 220 megawatt. So these are small modular reactors. These were their initial designs. And so for the longest time, when you were talking in India recently, and you were asking people in the nuclear energy sector about SMRs, it's something they dismissed because for the longest time, they were really aiming, so their standard pressurized heavy water reactor as on date is about 700 megawatt. That's their standard model. And they're looking at collaborations, light water reactors of 1,000 megawatt. And given the need in India, the mindset was not of going back to SMRs because they've seen it as a historical growth from a small indigenous technology to finally achieving these larger megawatt nuclear power plants. And of course, but I'll come to it, there's a recent change. They see the value in it, their collaboration opportunities, but still a long way to go. So I just thought I'd highlight this from the outset because it explains also a little bit maybe the view that you may still find when interacting with some of the people in the nuclear sector here about SMRs. But let me go to the next slide. So interestingly enough, India, I'll not go into too much detail given the constraint of time, but at least what we've seen for the first time is that we did have official references to small modular reactors. It's called the Bharat small reactor. Bharat means India in Hindi, for the first time in the recent budget. So that was interesting for all of us to note. Funds are being allocated to it, and they give a target, whether realistic or not, but at least to come up with 5 Indian-designed SMRs by 2033. And the budget also referred to a rather ambitious target of 100 gigawatt of nuclear energy by 2047. That sounds ambitious given my previous slide, and knowing that these 8,800 megawatt as on date still represent less than 3% of India's energy mix. So sure enough, people like the idea of it. There's a lot of know-how, technology, long history, but questions are being raised, of course, how India would achieve these goals. But maybe, and I've not included it in my slide, but I think it may be a good moment to also refer, and then maybe also to what Mary Spencer were referring to very recently, that is end of March 2025, the Department of Energy in the US gave what they refer to as a 10 CFR 810 regulation approval to Holtec to export some of its SMR technology, allowing also manufacturing and collaboration with Indian companies, the Tata Consulting Engineering Company and Larsen and Toubro. And that, of course, is a very important development, and I thought I'd flag it here. To be continued, of course, these are recent developments. But more importantly, most of you, but maybe for the benefit of course, all the people listening in, are aware of India's unique history, its long history of isolation. And what is interesting at this juncture is that there's also been explicit reference in this year's budget that the Civil Liability for Nuclear Damages Act, as well as the Atomic Energy Act, would be amended. Something, again, that many of us lawyers for the longest time thought would be impossible, that has been a demand for many, many years. And I'll just clarify so that the monsoon, the parliamentary session, will start here 2 weeks from now. And so the question is, we've been interacting with people at the Atomic Energy Regulatory Board in this sector. So it will either be tabled in the monsoon session now, so I hope there's a follow-up webinar, or in the winter session that is end of November. And I'll move to the next slide. This is important, and I just thought maybe I'll not cover all my slides, but I think India has a bit of three-phase history, right? One of isolation. It has always had, you know, a nuclear technology and a nuclear plan, mission, vision in place. Then, as many of you know, did opt to go for a peaceful nuclear explosion. We've seen the response of the nuclear suppliers group. I'll not go into too much detail, but as a result, for the longest time, India was really isolated from any nuclear trade. And it is only, again, without going into too much detail, that once the NSG waiver was obtained in 2008, that we saw a different era finally, foreign collaborations being made possible. Preconditional was, of course, that India also adopted a new legislation which was not in place before. So tort law used to apply before, just like in some of these newcomer countries. So the Civil Liability for Nuclear Damage Act was adopted in 2010. Accompanying rules, even an Indian nuclear insurance pool mechanism was set up soon after. India also ratified and ultimately it entered into for the Convention on Supplementary Compensation. But as many as you know, the CLMD Act was not phrased completely in tune with standard language from the CSC or what was global practice. So as a result, despite this enthusiasm in terms of finally having the opportunity to embark in this international nuclear trade, there has been a dampening effect precisely because the law was drafted in such a manner that it didn't give enough confidence to foreign players to come forward in the Indian market. And for the longest time, even in parliamentary debates, for the longest time, the calculation was that sure enough, the Indian market is interesting enough that despite our legislation, companies will come forward and invest. And that has not been the case. So very interesting. So there's been 15 years of actually this law being in place, and yet not seeing any, not the anticipated type of development in terms of international collaboration. So therefore, I think we find ourselves in a very interesting cusp where finally they're willing to amend the CLMD Act. And I'll go to the next slide. And so quite ambitiously, and of course we'll have to see in the next 3 weeks for these parliamentary debates, but at least what we know so far from some of the drafts circulated is that the Atomic Energy Act would be amended to allow private operators, as of now, only public sector undertakings and joint ventures between public sector undertakings can be nuclear operators. It seems that this will be amended as a first step. Similarly, the most controversial section of the CLMD Act, that is where you see an extensive supplier liability, will also be amended. And the hope is that it will simply be deleted and avoid any more confusions, right? Because there's been so many variations at the end. But of course, we will have to see how this moves forward. Similarly, there's been a demand from the sector, including the domestic sector, that a refined definition be made of what is a supplier and the sub-vendors. There's been a lot of reluctance even by sub-vendors to sign certain contracts. So we expect an amendment there too. And we also, as on date, the liability amounts for, in terms of the liability resting on the operator is not graded. So anything above 10 megawatt will really attract the same type of liability. So even here, the request has been made by industry at least to try to grade it. So we'll have to see how that will be approached. Similarly, some of you who followed the law a little bit more in detail, there are other controversial or very open-ended sections in the CLMD Act in terms of applicability of other laws vis-a-vis the operator. And of course, the request is also that this would be amended. And I'll go to the next slide Yeah. So just to flag that, as I said, so government company as of now historically has always been limited under the Atomic Energy Act of 1962 to only fully owned government companies. Only recently, because there was an amendment in 2015 that only entered into force in 2023, were joint ventures between these public sector undertakings allowed. And one such JV was set up very recently, 2024, between the Nuclear Power Corporation of India Limited and the National Thermal Power Corporation of India. But even here, so to be continued, we expect this also to be changed. I may flag here because, I mean, in tune of the overall theme, of course, of this session. So it's the Atomic Energy Regulatory Board, which is the regulatory authority for all these nuclear power plants, including for SMRs. We also know that as of now, you don't have any specific guidelines published by the ARB pertaining to SMRs. We do know that they're actively working on that. So even here, we expect such notifications very soon. So if you could go to the but maybe I should also clarify, just like in other jurisdictions, the ARB does insist that any reactor to be set up in India should be licensed in the country of origin. I think that's also a standard approach followed by the ARB as well. So we'll go to the next slide. Yeah, this is just to, I think we can skip that for the purpose of this session. So just to clarify that India has very much signed and ratified the CSC, and it's of course important to establish jurisdiction in particular. So next slide. So amounts of liability very much in tune also with the amounts embedded in the CSC and other treaties. So although even here we foresee that even in Parliament there may be discussions on this very point, because one cannot underestimate, it has been discussed in the past as well when the CLND Act was adopted, but sure enough, we anticipate that some of these discussions will take place on the amounts of compensation, which as of now, many NGOs, activists, and therefore probably also parliamentarians will see as low, and references are bound to be made to the compensation amounts which were seen as insufficient and very close to these amounts in the case of the Bhopal gas tragedy. And so that's always a shadow, that Bhopal gas tragedy, which happened in the 80s, but cast such a long shadow on any discussion when it comes even to nuclear. So we'll have to see how this will be navigated in Parliament. So next slide. As I said, so this is I've highlighted for the benefit of those who are not familiar enough with this section. I won't read it, but suffice to say, I've highlighted in red the one section that immediately catches the attention of everyone who studies nuclear law, international nuclear law. So the one controversial segment which was taken off and from a product liability concept, let's say, and then just injected in the act, was that even suppliers could be held liable in the case of supply of equipment or material with patent or latent defects or substandard services. Very unusual provision in the context of nuclear law, which, as we know, deviates very much from tort law in this regard. So next slide. Even here, the supplier definition was not embedded in the act, was amended subsequently in the rules drafted, let's say, by engineers with a lot of examples, but possibly adding more confusion, knowing further that the way it has then been applied, the definition of a supplier, is that at the end, in day-to-day practice, including in tenders and in contracts with the NPCL, is that at times the Nuclear Power Corporation of India Limited, when it came to its own standard 700 megawatt PHWR designs, was willing to say, with regard to our own designs, we believe the supplier definition covers us. So you would have a situation where both the operator would not be willing, historically, of course, before the CLND Act, NPCL would sign hold harmless clauses. But in this case, because the CLND Act then came to apply and say, well, for this very contract, the operator must also be considered as the supplier. And so sure enough, all these interpretations and practical application do catch the attention of all the international lawyers, because it's a slightly unusual approach. So we assume that even here, there will be further clarity shedded once we have these amendments in place. So we can go to the next slide. Yeah, so as I already mentioned, I'll not dwell on it. So, but you've had this rather original and creative application of who is the supplier, in this case also being the operator. But many sub-vendors were never at ease, because at the end of the day, your supplier definition is not in your main act, is in the regulations. You have all these creative applications, and sub-vendors, sure enough, have been asking for years, this should be defined very clearly. At least we should be excluded as sub-vendors in a definition in the main act. So we assume that that will also be addressed. Next slide. And as you know, I think there's been attempts over the years by the Ministry of External Affairs to try to add, to shed clarity to this section, this controversial section, by saying, as much as Section 17B gives the right to a right of recourse by the operator to the supplier, of course, it was phrased such that it merely gives the right, but everyone understood when it came to the operator, in this case, NPCL, a public sector undertaking, that there would not be too much discretion, so to speak, because there would otherwise questions being raised on, let's put it, the discretion applied, the ethics involved, if NPCL would decide not to pursue its right of recourse. Right, so of course that again would change in the event that you have a private operator, which would not have these same public concerns. But sure enough, it was understood that the right of recourse would have to be relied on by the Nuclear Power Corporation of India. We'll see a little bit further in the next slide how, maybe I'll just go straight because I'm not sure how much time I have. So we can go to the next slide. At the end, so this is another section that we anticipate will be amended as well, where indeed some of the other laws are made applicable to the operator as well. But I think that the point I want to make before wrapping up is that all, if we go to the next slide, so given the ambiguity of the fact that the discretion given to the operator to exercise its right of recourse, which it was understood it would have to be, otherwise valid questions could be raised on its decision not to do so. Interestingly, it is via the nuclear insurance pool mechanism that a solution was tried to be offered. In this sense, another, let's say, rather creative approach in India that we found is that the Indian Nuclear Insurance Pool, set up in 2015, would issue a floater policy to NPCL for all its nuclear power plants, and then depending would keep adding. At the same time, and of course it was understood NPCL was obligated to take this insurance. Suppliers are not necessarily obligated to take such an insurance, but INIP would be offering such an insurance to the supplier as well. And if we can go to the following slide. So what INIP then suggested is that would be subrogated in the rights of the operator to those suppliers where it was highly recommended that they would also take such insurance from INIP. INIP, well, its administrator, would also be subrogated in the rights of the supplier in case the operator would decide to exercise its right of recourse. So as a result, this would be settled very much in before in an insurance model, so would not even go to court. So this is a bit how this was presented. But sure enough, even this model is trying to offer a solution to the unique setup under the CLND Act. And it was also based on the assumption that the NPCL would always exercise its right of recourse. Once you have private operators who, of course, have a different discretion in this regard, even the whole insurance model would have to be changed, because INIP has also made it very clear that the day, because it makes its own risk calculations, and so that merely waiving that right of recourse would, by a private operator, would completely change the dynamics for the insurance world as well. And so even this structure that has been put in place, we foresee will have to be changed, not amended, because it's of course just a model put forward by the market as such, but would have to be tailored and probably realigned with what we find abroad as well. So lots of unique elements here in India, and we do look forward to a more simplified approach going forward. Thanks.
Thank you very much, Els. And I think we all look forward to seeing what may happen with the legislative change. That's great. Thank you.
Yeah.
I think we have Beata back.
Yes.
Beata, we had some tech issues, so hopefully it will go smoothly now. I turn
Yes.
back to you.
Apologies for what happened. Oh yes, I can see my slides, and I'm informed that you lost me on the very first slide. So I'll start from the beginning. Thank you, Els, for taking over so quickly. So I'll highlight some considerations for an embarking country in which both gigawatt and small modular reactors are implemented. The status of the projects which are implemented in Poland is also differentiated. 2 projects are government-led, while others are private or semi-private. And if we could go to the first slide, please, to the next slide, please. Thank you. The governmental Polish nuclear power program envisages implementation of 2 large-scale projects on 2 sites with total capacity of 6 to 9 gigawatts, using proven generation-free light water reactors technology. The aim is to produce large amounts of clean electricity and possibly also district heat. As regards the first site, the project is implemented by Polskie Elektrownie Jądrowe, PEJ. This is a 100% state-owned company cooperating with Westinghouse Bechtel Consortium using the AP1000 reactor technology. And in 2023, the investor obtained the so-called decision in principle for this project. The decision in principle is a decision which is issued by the minister in charge of energy, and this is a green light to the projects, including the site, including the technology, and also taking into account the national energy policy as well as the projected electricity demand, so all these factors. And it's the first decision which is obtained in the investment process. It allows the investor to apply for subsequent administrative decisions, such as the location decision or construction permit. It is aimed to reduce investment risks by putting the state approval at the beginning of the licensing process. And this is especially important for non-governmental projects, including the SMR projects, which are developed outside the governmental program. So in 2023 and 2024, 4 investors received decisions in principle outside the governmental program. One of them, and you can see it in the middle, is another large-scale project. It is business-driven project, however, with the involvement of state-controlled Polish energy group. So it's a mixed situation here. And decision in principles were also issued to 3 SMR investors, out of which the most advanced projects are those which are developed by Orlen Synthos Green Energy using GE Hitachi BWRX technology. It is worth noting here again that the situation is is somehow mixed, because Orlen is also a state-controlled company. However, the project is business-driven and it is implemented outside the governmental program. So next slide, please. So thank you. The Polish nuclear power program is implemented by the Minister of Industry, who is the NEPIO. And the minister issues decisions in principle also to private investors, so outside the program. The program is currently updated. However, despite the parallel investments, including the SMR investments, the program will, even after the update, it will still cover only large-scale government-led investments. So all the other investments will still be outside the program. However, we also envisage to adopt a SMR roadmap, which will may not govern, because it will be the sort of it will mention the parallel investments in SMRs that are undertaken. So we consider gigawatt projects and the SMR projects as complementary in the Polish situations. SMRs will have a different role to play in the Polish power sector. They will be usually built for specific applications, mainly to cover companies' own energy needs. And these private and semi-private initiatives, we hope, will mobilize private capital and help
Oh, I think Beata has frozen.
Equal treatment of those off-program entrepreneurs, and ensuring technology neutrality among the SMR technologies, but also among the gigawatt and SMR projects. This is why, contrary to what previous speakers said, in Poland, no specific legal arrangements are envisaged for SMR technologies, nor preferential conditions are envisaged on this stage. And the framework, the current legislative framework, is considered at this stage flexible enough to accommodate both gigawatt and SMR technologies, and also the AMR technologies which are developed. And next slide, please. Thank you. So electricity demand forecasts in Poland indicate a significant increase over the coming decades. So feasibility analysis of building additional nuclear power plants will continue. It may be necessary to consider locations which are not addressed, which have not been addressed in the previous versions of the governmental program. However, existing criteria will be used here, such as the aim to replace coal capacity, which will be phased out, as well as ensuring power system flexibility. The implementation of program projects may not be possible without some forms of state support. We recognize that. This support may be provided to an extent allowed by the state of public finances, and after a transparent assessment of each project. What will be assessed is the project's credibility, maturity, its impact on economy, and it will be done in a way to ensure equal treatment of all investors. Furthermore, the participation of non-governmental investors in the costs of maintaining the broadly defined nuclear energy infrastructure will be anticipated, but we don't have the details yet. But this is this will be further analyzed. Next slide, please. Thank you. So as regards the regulatory body, regulators currently face a similar challenge of keeping up with emerging SMR technologies. So to this end, a special unit for SMR pre-licensing activities was established within the Polish regulator. Its main tasks include the assessment of applications for the general opinion. I'll say in a minute what the general opinion is. Another task is creating guidelines and Also, this unit participates in international SMR initiatives. However, it is important to underline that for the regulator, it does not matter whether the technology is large or small. Every assessment must be conducted in the same prescribed manner for the time being. And next slide, please. I'll talk about legal arrangements to streamline the investment process for nuclear power plants. Legislation provides for a number of changes to various national laws which are applicable to nuclear power plant projects. As previously mentioned, in view of the technology neutrality principle, no specific legal arrangements are envisaged at this stage for SMR technologies. Neither lowered third-party liability limits are envisaged or even allowed under the Atomic Law Act. The Atomic Law Act explicitly states that the liability amounts for nuclear installations are 300 million special drawing rights, and there are no exemptions from this amount. So it will, for the decision that has been taken for now, is that there will be no lowered limits for SMR IMR technologies. And here I'll just give you a few examples of legal arrangements which are aimed at facilitating the implementation of nuclear power projects. So we have the decision in principle that I've already mentioned, how it works. There are also some pre-licensing instruments. These instruments are particularly interesting for SMR investors. So before applying for a license, the investor may apply for a general assessment of the plant organization and technical solutions. The assessment can include the draft versions of documents that will be submitted along with the license application. The general assessment, the general opinion is not a generic design assessment that is foreseen, for instance, under the UK law. This has a different aim, and it is not a mandatory opinion. So it's up to the investor whether he wants to apply for it or not. Furthermore, the investor may apply for preliminary assessment of the plant site. This is another element of the pre-licensing instruments. And there is also a possibility of parallel administrative proceedings to issue various licenses and permits. In such cases, the investor does not have to wait until license A is issued before applying for license B. And furthermore, there are all the mechanisms that facilitate conducting site surveys and environmental impact assessments, as well as administrative fast track to construct auxiliary infrastructure. And next slide, please. And this will be the final slide. These are just a few takeaways from what we've learned so far in the process. So first of all, the establishment of a team for the development of nuclear projects, which comprises all nuclear power investors, so both gigawatt investors and SMR investors. It turned out to be useful. It serves as a single point of contact. Therefore, it was a good decision to establish such a team. A challenge I would like to point to is when many nuclear projects are implemented at the same time, which is the Polish case. So there's a project of so-called cannibalization, we call it. It's not a nice name. However, it exists, and we'll have to deal with that in view of scarce human resources and regulatory resources. Also, what we see is the competition between gigawatt and small modular reactors projects. In Polish situation, we also deal with the nuclear coal competition, with the renewable nuclear competition. So there is all the time there is this climate, let's say, of competing projects, competing technologies, and somehow you have to deal with it. You have to deal with this. And what should be avoided from what we've learned is public statements that could be made indicating that somehow large-scale technologies are not safe or are no longer economically viable. Such statements are difficult to avoid in view of competition between projects. However, it's important to recognize that they do not act to the benefit of the nuclear sector as a whole. And recognizing this problem, this is also one of the reasons that we stick to the technology neutral approach. This is also in order not to send a signal to the public that some technologies are less safe than others. So with this, I would conclude. Thank you very much for your attention.
And thank you very much, Beata. That was great. I'm glad we got the tech working again.
Yeah.
Now I will turn it over to Kristen Weiss, who's going to speak to us about fusion. Over to you, Kristen.
Thank you. Thank you, Lisa, for the introduction, and hello, everyone. In addition to my work as an energy lawyer, I'm conducting research as a PhD candidate on fusion regulation, particularly under German law. It seems surprising to hear a German voice here due to the phasing out decision regarding nuclear energy. However, and the presentation will show this is not a contradiction in terms of nuclear fusion. Today, I'd like to give an insight into the regulatory challenges related to nuclear fusion, a technology that has long been considered science fiction, but is now coming closer to scientific and commercial reality. But to begin, I would like to take a step back from the core question of fusion regulation and would like to have a quick look to what is nuclear fusion and how is it different from nuclear fission. Next slide, please. And we're going to the next slide. So what is nuclear fusion and how is it different from nuclear fission? To set the stage, let's briefly compare nuclear fusion with the nuclear technology we are all familiar with, nuclear fission. So nuclear fission involves splitting heavy nuclei like uranium or plutonium into smaller ones, releasing energy in this process. Next slide, please. Fusion, on the other hand, works by, in fact, fusing light nuclei, usually isotopes of hydrogen, such as deuterium and tritium, into a heavier nucleus. Here in this example, helium. This reaction also releases a huge amount of energy. And this leads me to the next question. Next slide, please. Of the key advantages of nuclear fusion. Next slide, please. Nuclear fusion is inherently safe because fusion reactors, they require extremely high temperatures, about 150 million degrees Celsius, and pressure to occur. If these conditions are disrupted, for example, because a stopping of the fuel supply, the reaction simply stops. So therefore, there's not a risk of a runaway chain reaction. Another aspect that I would like to highlight is the aspect of radioactive waste. Fusion does generate some radioactive waste, mainly tritium and neutron-activated materials, but these are short-lived, decaying within decades or a few hundred years, unlike fission waste, which remains radioactive for tens of thousands of years. But as I mentioned at the beginning, fusion energy was long considered science fiction, which leads us to the following question. Next slide, please. Where do we stand in 2025? Next slide. You may have heard the joke that fusion is always 40 years away. The joke has been around since fusion research started in the 1950s. But the truth is, the fusion industry is making progress. Recent breakthroughs, for instance, the successful experiment at the National Ignition Facility in the US, where for the first time more energy was released out of the fusion reaction than was put into it, or the ongoing ITER project in France, or the many, many startups we see in the fusion industry around the world have brought fusion closer to technical feasibility. Still, commercial fusion is not here yet, but the time to prepare legal framework is now, because once technology becomes scalable, we will need laws in place that support innovation while ensuring safety and public trust. And last but not least, the fusion industry, they need regulatory certainty that governs the construction and operation of prototype fusion facilities. Next slide, please. Against this backdrop, regulatory challenges arise, and the question on how this new technology, nuclear fusion, should be regulated needs to be answered. Next slide, please. The first question which needs to be addressed is if the existing fission frameworks can apply. Actually, this was the initial question for this presentation today on how fusion fits into traditional fission frameworks. And well, fusion is often grouped under the term of advanced nuclear, but it's fundamentally different from nuclear fission. It comes with distinct physics, safety profiles, and regulatory needs, and it deserves its own regulatory consideration. So as I'm a German-based lawyer and researcher, I want to take Germany and German law here as an example. Under German law, there are two existing legal frameworks that may regulate nuclear fusion. First is the Atomic Energy Act, and the second is the Radiation Protection Act. The Atomic Energy Act, as we call it, the German Atomgesetz, was created to address the specific risks of nuclear fission. For example, the risk of chain reactions, the use of nuclear fuel, high-level radioactive waste, etc. It must be stated that fusion, while involving radiation, does not pose these same core risks and does not use nuclear fuel in the legal sense of the Atomic Energy Act. So therefore, in Germany, most researchers and stakeholders agree that fusion should not fall under the Atomic Energy Act because two reasons. The act is focused on the use of nuclear fuel, especially uranium and plutonium, which are not used in fusion. And the act is designed for a technology, nuclear fission, with entirely different safety profiles and waste characteristics. But still, a fusion reactor, and I think everyone is clear on that, needs to be regulated, mainly because they contain radioactive material like tritium, and therefore shielding and containment is required. But instead of the Atomic Energy Act, under German law, the Radiation Protection Act is seen as a better match. It regulates radioactive substances and exposure regardless of the specific technology behind them. And that's precisely what fusion involves. Radioactivity in form of neutron activation and tritium handling, but no nuclear fuel, high-level radioactive waste, or the risk of a chain reaction. So in short, fusion involves radiation, yes, but not in a way that justifies regulation under traditional fission frameworks. So which leads me to the next slide. Next slide, please. The two legal approaches for fusion regulation under German law. Yes, thank you. The first one is to adapt the existing frameworks. This could mean applying whether the Atomic Energy Act or the Radiation Protection Act to fusion installations, with, of course, modifications where needed to address fusion-specific hazards or to ensure legal certainty. This approach has the benefit of legal continuity, but carries also the risk that the legal instruments will no longer correspond to the actual risks posed by the technology of fusion. The second approach is to create a new legal framework for fusion. This is a more ambitious solution, but As the regulation is being created from scratch, this would enable a risk-based, proportionate approach, regulating what needs to be regulated without overburdening. However, the issue of fusion regulation has also a political dimension. Next slide, please. And we can also, yeah, thank you. So ultimately, this is not just a legal debate. However, how fusion technology will be regulated is a political decision. For Germany, the regulatory decision has not yet been made as to whether future fusion facilities will be regulated under the Atomic Energy Act or the Radiation Protection Act, or whether a new fusion act will be created. What's essential, and regardless of the legal basis, is, and I would like to highlight two aspects here, is that legislators should be aware that nuclear fusion is a fundamentally different technology that requires a separate regulatory approach than nuclear fission. And the second one is that the regulatory frameworks must strike a balance between ensuring safety while remaining flexible and innovation friendly, especially in the early stages of market development. Next slide, please. Next slide. Yeah, thank you. To wrap up, whether countries succeed in integrating fusion into the future energy systems depends not only on scientists and engineers, but also on lawmakers and regulators. The creation of an appropriate legal framework, in particular one that is risk-based and balanced, will be crucial to realize the future use of fusion energy. Thank you very much for your attention, and I look forward to your questions and the discussion.
Thank you very much, Kristen. I'm mindful of time, and I don't think we're going to actually have the chance to have a Q&A session. We have noted the questions in the chat, and unfortunately, because we've spent our time listening to our fabulous speakers, we haven't got time to discuss them here. If you would like to reach out to a specific panelist after the event, please feel free to do so. And if you can't find their contact details in order to get in touch with them, then please reach out to Winley and we will try to put you in touch with them. So I want to thank everyone. And before we sign off, I would like to give the floor over to the NEA's head of the Division of Nuclear Law, Kimberly Nick, so she can spend a couple minutes talking to us about the NEA's upcoming workshop, Bridging Law and Technology, International Workshop for the Deployment of Small Modular Reactors. And so I'll turn that over to you, Kimberly.
Thank you so much, Lisa. And I just want to briefly mention the fact that if the discussion that we had here today was of interest to any of you, we're going to be delving much, much deeper into these subjects at the end of the year from the 8th to the 10th of December in Stockholm, Sweden, for our really state-of-the-art workshop. Next slide. So this workshop is going to be answering the key question: are legal frameworks in place for the wide variety of innovative nuclear technologies and applications under consideration? Here, we're going to try to bring together legal, technical, and policy experts from both the government and the private sector to discuss the unique legal challenges posed by advancements in small modular, transportable, marine, and Generation 4 reactors, and identify potential paths forward on challenges faced in these areas. We're going to have 5 thematic half-day sessions covering authorizing small modular reactor designs, SMR pre-licensing and licensing challenges, including siting, environmental reviews, and public participation. Factory manufacturing, mobile reactors, and transportation. 4th, marine applications, which looks at propulsion, offshore and onshore power. And finally, fuel cycle, waste management, and decommissioning. Next slide. One of the really great things about this workshop, we want it to be interactive and collaborative to actually look at advancing paths forward in addressing these challenges. We're going to have a working group structure designed to develop pre-workshop preparatory materials. We'll be meeting in advance of the workshop virtually to look at early engagement with other workshop participants, collecting background information, having surveys, presentations, group discussions, and then developing pre-workshop discussion papers summarizing those legal and technical information that we found, current legal and technical framework, and challenges to really address in the workshop. Access to the working groups and all of the information that we develop ahead of time is only going to be available in advance of the workshop to those who've signed up for the workshop. So this is an incentive to make sure that you both sign up for the workshop and do it early. It's going to be moderated by Paul Bowden. For those of you who've been to the NEA's nuclear law education programs, a dynamic, well-informed, fantastic moderator. So he's going to be leading us through these different sessions. DG Magwood's going to be participating, as well as senior representatives from the Swedish Ministry of Climate and Enterprise. Next slide. We're going to have a lot of discussion, a lot of audience participation. We're really looking forward to this. It's open to 200 participants. Registration fees are here for you. It shows you attendance to the 3-day workshop, all of our pre-workshop working group activities, coffee breaks, refreshments, lunches, a cocktail reception, a workshop dinner. Next slide. Basically, sign up now. Early registration is highly recommended. We've got more information here. These slides, along with all of the others from our participants, are going to be posted online on the NEA's website. And so this was just a little bit of a taste for those of you who are interested from what we discussed here. And we hope to see you all together in Stockholm in December. Thank you.
Wonderful. Thank you, Kimberly. Yeah, a little teaser for something that will be fabulous. So I think we've come to the end of our second Women in Nuclear Law Initiative webinar on nuclear law considerations for advanced reactors. Thank you to everyone who has joined in, and we hope to see you all again for our next webinar. So stay tuned, it will be announced soon. Thanks so much, everyone.
Thanks so much. Over and out.
Bye, all.
Bye, everybody. Thanks so much.